Good day, class. Today we'll discuss obligations under the Civil Code, specifically Articles 1163 to 1178. This is a foundational topic, not only in law but also in accounting, especially when dealing with contracts, liabilities, and provisions. Now let me start with a basic question, something we already touched on in our previous lecture. What is an obligation? An obligation is a juridical necessity to give, to do, or not to do. In simple terms, it is something that the law requires a person to perform, or to refrain from performing. Let's break that down further by classifying obligations. First, we have what we call real and personal obligations. You can actually derive this directly from the definition I just gave. A real obligation refers to an obligation to give. This means there is a specific thing or object that must be delivered. For example, Ren's promised to deliver a laptop to you. That is a real obligation. On the other hand, a personal obligation refers to an obligation to do or not to do. This involves an act or service. For instance, if I agree to repair your computer, that is an obligation to do. If I agree not to open a competing business within a certain area, that is an obligation not to do. No delivery of a thing, but rather a performance or non-performance of an act. Now, let's connect this to Article 1163 of the Civil Code. It states there that every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. So what does that mean in practical terms? It means that if you are required to deliver something, you are not only responsible for handing it over, you are also responsible for taking proper care of it while it is still in your possession. Think of it this way. If you promise to deliver a specific laptop next week, you cannot just leave it anywhere or neglect it. You are expected to take reasonable care of that item, just like a responsible person would. Now, from an accounting perspective, this becomes relevant when we recognize obligations as liabilities. When a company commits to deliver goods, that obligation exists even before the actual delivery happens. And along with that obligation comes responsibility, sometimes even risk, which may affect how we measure or disclose that liability. So remember, an obligation to give is not just about delivery. It also carries the duty of preservation. Alright, class, let's move forward. Now we distinguish between determinate and generic obligations. This is a very important classification because it affects delivery, risk, and even liability. Let me explain this in a simple way. A determinate obligation refers to a specific identifiable thing. When we say specific, we mean it is clearly designated. You can point to it and say, this exact item. On the other hand, a generic obligation refers to a class or kind of thing. It is not specific. It only refers to a category, not a particular object. Now, let's make this clearer with examples. For a determinate obligation, suppose I say, I will give you my red Toyota Vios with plate number ABC123. Notice how specific that is. There is no confusion about what must be delivered. It is one particular car, color identified, plate number identified. Because it is determinate, the law gives the creditor stronger rights. Under Article 1165, the creditor can actually compel me to deliver that exact car. I cannot substitute it with another vehicle. Also, under Article 1166, I am not only required to deliver the car itself, but also everything attached to it, its accessories and accessions. That includes things like the car keys, installed stereo system, or any included parts, even if not mentioned. Now here's a very important point. If that exact car is lost or destroyed without my fault, for example due to a natural disaster like a flood, then the obligation is extinguished. Why? Because the specific thing no longer exists. But remember this, if I am at fault or if I am in delay, I can still be held liable for damages under Article 1170. We'll elaborate this further later. Now let's compare that with a generic obligation. Suppose I say, I will give you a Toyota car. Now, is it a specific car? No. It could be any Toyota car. The obligation refers only to a class or kind. Because of this, even if one car is destroyed, my obligation is not extinguished. I can still comply by delivering another Toyota car. This is where the principle comes in. Genus never perishes. Generic things do not perish, because they can always be replaced. Now going back to Article 1165, if the obligation is generic and I refuse to comply, the creditor cannot demand a specific item, but they can have the obligation performed at my expense, meaning they can obtain the item elsewhere and charge me for it. Now let's connect this with the risk of loss and liability under Articles 1170 to 1174. Under Article 1170, the law says that a person who is guilty of fraud, negligence, delay, and those who in any manner contravene the tenor thereof, is liable for damages. So let's apply that and make it as simple as possible. First, if I intentionally sell the same car to another person because he offered a higher price instead of delivering it to you, I am liable. Why? Because there is fraud or bad faith. Now, if I am supposed to deliver that specific red Toyota Vios, and I negligently leave it unlocked and it gets stolen, I am liable. Why? Because there is negligence. What about delay? If I delay delivery, and during that delay the car is destroyed by a flood, I am still liable. Why? Because delay transfers the risk to the debtor. And at last, if I deliver a different car, like a black Toyota Vios instead of the agreed red Toyota Vios, I am liable. Why? Because I contravened the tenor of the obligation. Or to put it simply, I violated the term of the obligation. Here's a quick memory trick for you. There are 4 ways to become liable. Fraud means intentional violation. Negligence means carelessness. Delay means late performance. And contravention means wrong performance. Now, here's the catch. What if the loss is due to a fortuitous event, something unforeseeable and unavoidable, like an earthquake? Under Article 1174, as a general rule, I am not liable for such events. But remember that it is only a general rule. Now, what are the exceptions? Normally, if a thing is lost due to a fortuitous event, like a flood, earthquake, or fire, the debtor is not liable. But take note, this only applies if there is no fault or negligence, there is no delay, and there is no agreement assuming the risk. Otherwise, I can still be held liable. Let's use the previous example. I promised to deliver that Toyota Vios to you on March 10th. But I failed to deliver it on that date and you made a demand. So I am now in delay. Then on March 15th, a flood destroys the car. Now you might think, ma'am, that's a fortuitous event, so no liability, right? Wrong. Because I was already in delay, I will still be held liable. The law shifts the risk to me. Even though the loss was not my fault, I bear the consequence because I failed to deliver on time. So let me simplify the rule for you. If there is no delay and no fault, in case of fortuitous event, there's no liability. But if there is delay or double sale of the same thing and there's a fortuitous event, I am still liable. And remember this key idea. The law protects the creditor. Once the debtor acts improperly, whether by fraud, delay, or negligence, or by making conflicting promises, the debtor can no longer escape liability by using fortuitous event as an excuse. So always ask yourself, was there delay? Was there fault? If yes, then liability remains, even if the event was beyond control. Now going back, let me summarize the difference between determinate and generic obligations. For determinate obligations, specific item, if there's a loss without fault, the obligation will be extinguished, creditor can demand exact delivery, and it includes accessories and accessions. For generic obligations, it involves class or kind, loss does not extinguish obligation, and can be substituted with another item, because of the concept that genus never perishes. And always remember, liability arises when there is fraud, negligence, or delay. That is the key factor that determines whether a debtor will be responsible for damages. Now, let's discuss another classification of obligation. Let's differentiate positive and negative obligation. A positive obligation refers to an obligation to give or to do. In other words, there is something that the debtor must actively perform. On the other hand, a negative obligation is an obligation not to do. This means the debtor must refrain from performing a specific act. Let's make this clearer. For a positive obligation, suppose I say, I will build a house for you. Here, I am required to perform an act, to construct the house. Now, what if I fail to do it? Under Article 1167, if a person obliged to do something fails to do it, the obligation may be executed at his cost. In simple terms, the creditor can hire someone else to build the house, and I will be the one to pay for it. But there is another situation you must understand. What if I did build the house, but not according to what we agreed? This is what we call contravention of the tenor of the obligation. For example, if I was supposed to build a 2-story concrete house, but I only built a 1-story wooden house, I technically performed, but I did not follow the agreement. This is called improper or defective performance. In this case, the law allows the court to order the correction of the work, or even require that what has been poorly done be undone, again at my expense. Or to put it simply, the court can order the structure to be demolished or removed, and I will shoulder the cost. So take note of this important point. In positive obligations, liability arises not only when you do not perform, but also when you perform incorrectly. Now, let's go to negative obligations. Here, the obligation is to refrain from doing something. Now, here is the rule under Article 1168. If the debtor does what has been forbidden, the act shall be undone at his expense. Let me give you a concrete example. Suppose I promised not to build a fence on a certain property. However, despite that promise, I still constructed a fence. What can the creditor do? The creditor can go to court and demand that the fence be removed. The court can order the demolition of the fence, and I will shoulder all the costs. Now, let's clearly compare the two. For positive obligations, if I do not perform or perform improperly, the act can be completed, corrected, or redone at my expense. For negative obligations, if I violate the obligation, the act will be undone at my expense. So whether the obligation requires action or restraint, the law ensures that the creditor is protected and that the agreed terms are properly enforced. That's the key takeaway you should remember. Alright, so much for the classification. Let's now discuss the responsibilities of the debtor. Under the Civil Code specifically, Article 1163, 1164, 1166, and 1170, the debtor is not only required to perform the obligation, but also to comply with certain duties connected to that obligation. There are 4 main duties you need to remember: preserve the thing, deliver the fruits, deliver accessions and accessories, and pay damages in case of breach. Now, instead of giving separate examples, let me give you one complete scenario so you can see how all of these apply together. Suppose I sold you a mango farm on January 1, and we agreed that I will deliver it to you on February 1. Let's analyze my responsibilities as the debtor. First, preserve the thing. While the farm is still in my possession, from January 1 to February 1, I am required to take care of it properly. I cannot neglect the trees, I cannot allow damage or destruction. This is what the law means by diligence of a good father of a family under Article 1163. In simple terms, I must exercise reasonable care. Not extraordinary, but definitely not careless. I must act like a responsible owner. Second, deliver the fruits. Under Article 1164, once the obligation arises and there is already a demand, the fruits belong to the creditor. So if mangoes are harvested during that period, after demand has been made, those mangoes already belong to you, not to me. Even if I am still in physical possession of the farm, I must account for those fruits. Third, deliver accessions and accessories. Under Article 1166, I must deliver not only the farm itself, but everything that goes with it. This includes irrigation systems, farming tools attached to the land, and storage structures or improvements. Even if these were not specifically mentioned, they are included in the delivery. And for the last duty, pay damages in case of breach. Now, what if I fail in my obligations? For example, I neglected the farm and the trees died. I harvested and sold the mangoes for myself. I removed some equipment before delivery. In all these cases, I will be liable for damages under Article 1170. That means I must compensate you for the loss of the property's value, the value of the fruits, and any injury or damage caused. So, let's summarize this. As a debtor, I must take care of the farm, give you the mangoes, include everything attached to it, and if I fail in any of these, I pay damages. That is how the law ensures that obligations are not only performed, but performed properly and fairly. That's the full picture of the debtor's responsibilities. Alright, class, now let's look at the other side, the creditor. Since we already discussed the duties of the debtor, let's now focus on the rights of the creditor. So the question is, what can the creditor legally demand or enforce? Let's begin with Article 1165. The law says that when what is to be delivered is a determinate thing, the creditor may compel the debtor to make the delivery. So what does this mean? If the object is specific, for example, a particular car, the creditor has the right to demand that exact thing, not a substitute. Again, for example, if I promise to deliver my red Toyota Vios with plate ABC 123, you can go to court and compel me to deliver that exact car. This is what we call the right to demand performance. Now, aside from demanding delivery, the creditor also has the right to fruits. Under Article 1164, once the obligation becomes demandable, the fruits of the thing belong to the creditor. For example, if I am obliged to deliver a mango farm, the harvested mangoes already belong to you from the time of demand, even if I still physically possess the farm. Almost similar to the debtor's duty, right? Because you are at the receiving end of that duty. So those are the basic rights: right to demand performance and right to fruits. Now, let's move to something more advanced: the remedies of the creditor under Articles 1177 and 1178. These provisions protect the creditor when the debtor is trying to avoid payment or is neglecting his obligations. Under Article 1177, the law gives two important remedies. First is what we call acción subrogatoria. This means the creditor can step into the shoes of the debtor and exercise the debtor's rights. Let me explain. Suppose D owes C 100,000, but D is also owed 100,000 by X. Now here's the problem. D refuses or neglects to collect from X. Because of this, C is prejudiced. He cannot collect because D is inactive. So what does the law allow? C can go after X directly, and C can steps into D's position and collects the 100,000 from X. This is acción subrogatoria. But take note of the key condition. The debtor must be negligent or inactive in enforcing his own rights. Now, let's go to the second remedy under Article 1177, acción pauliana. The law also says that creditors may impugn acts done by the debtor to defraud them. This is the basis of acción pauliana. And this is a remedy to rescind fraudulent transfers. Meaning, if the debtor transfers property just to avoid paying debts, the creditor can ask the court to cancel that transaction. Let's use an example. D owes C 500,000. To avoid paying, D transfers his only land to a friend. Now clearly this is done to escape liability. What can C do? C can file acción pauliana, ask the court to cancel the transfer, and recover the property so it can be used to satisfy the debt. But remember, there are conditions before this remedy can apply. There must be a valid credit. The debtor performed a fraudulent act, the creditor has no other legal remedy available, and the act caused damage to the creditor. Now, let's briefly connect this with Article 1178. The law says that rights arising from obligations are generally transmissible, meaning they can be transferred to others, unless there is a stipulation prohibiting it. For example, if I am a creditor, I can assign my right to collect to another person, unless the contract says otherwise. This is important in practice, especially in accounting and business, where receivables can be assigned or sold. Remember the assignment and factoring of accounts receivable in your intermediate accounting class. That's what we mean by that. Now, to make things very clear, let's summarize the two remedies. For acción subrogatoria, the creditor exercises the rights of the debtor. It is used when the debtor is inactive. And for acción pauliana, the creditor rescinds fraudulent acts, and it is used when the debtor is acting in bad faith. So think of it this way. If the debtor is doing nothing, use subrogatoria, but if the debtor is doing something fraudulent, use pauliana. That's the key distinction. So overall, the law equips the creditor with strong rights, not only to demand performance, but also to protect themselves when the debtor becomes negligent or dishonest. That's the full picture of the creditor's rights. Alright class, earlier we already touched on risk of loss in determinate and generic obligations. Now let's go deeper and talk about the specific circumstances affecting obligations in general, particularly under Article 1170. The law provides those who in the performance of their obligations are guilty of fraud, negligence, delay, or in any manner contravene the tenor thereof, are liable for damages. So what does this mean? In simple terms, if the debtor performs the obligation improperly, whether intentionally, carelessly, late, or incorrectly, he will be liable for damages. Sounds familiar, right? This is what we discussed earlier, but now, let's discuss each one clearly and systematically. Let's dive deeper this time. First, what is fraud? Fraud refers to intentional wrongdoing. There is bad faith. Now, fraud can be classified into two. First is dolo causante. This is fraud that induces the contract itself. Without the fraud, the contract would not have been entered into. Example, I trick you into buying a car by lying that it is brand new. The contract may be annulled. Now, for the second one. It's called dolo incidente. This is fraud in the performance of the obligation, not in its perfection. Example: I agreed to deliver a brand new car, but I knowingly deliver a used one. The contract remains valid, but I am liable for damages. And under Article 1171, responsibility arising from fraud is demandable. This means that responsibilities are demandable, regardless of the type of obligation, whether it's a contract, quasi-contract, or other legal obligation. It also states there that any waiver of an action for future fraud is void. This means that parties cannot agree in advance to give up their right to hold someone liable for future fraud. In simpler terms, you can't sign a contract saying, "Even if you trick me later, I won't sue you." The law considers such waivers against public policy because they encourage dishonesty and abuse. Now let's talk about negligence. Negligence refers to failure to exercise proper care. Now, what is the degree of care required? First, follow what is required by law. For example, a common carrier must exercise extraordinary diligence, which means they must ensure maximum safety. They are required by the law, and even slight negligence can make them liable. This is based on Article 1733 of the Civil Code. You can check that for further discussion of vigilance over goods. Second degree of care required is to follow what is agreed upon by the parties. If neither applies, use the standard of a good father of a family. It means reasonable and ordinary care. Let's now classify the three types of negligence. First is culpa contractual. It is the negligence in the performance of a contract. For example, failing to safely deliver goods. The second type is culpa aquiliana. It is a negligence that is not based on contract like in quasi-delict. For example, causing damage to another's property. And for the last type, culpa criminal. It pertains to negligence resulting in a crime, for example the case of reckless imprudence. And take note that under Article 1172, responsibility arising from negligence in the performance of every kind of obligation is also demandable. But such liability may be regulated by the courts, according to the circumstances. This means that the law allows courts to adjust the amount or scope of damages depending on the circumstances. This recognizes that not all negligence is equal. Some may be minor mistakes, while others may be grossly negligent. Now let's talk about delay. Delay is not just being late, it has legal requirements. As a general rule under Article 1169, delay begins only from the time the creditor makes a demand upon the debtor, whether judicial or extrajudicial, for the fulfillment of the obligation. Judicial basically means it is filed in court, while extrajudicial means that demand was made outside the court, like a formal request, such as lawyer's demand letter. This means that even if the obligation is already due, the debtor is not considered in delay unless such demand has been made. So without demand, generally there is no delay yet. However, Article 1169 provides three important exceptions where demand is not required for delay to occur. First is when the law or contract expressly states so. If the agreement says that delay begins automatically, then demand is unnecessary. For example, if payment is not made on June 1st, the debtor is automatically in delay. Second exception is when time is the controlling motive. This means the exact time is very important in the agreement. Example, delivery of a wedding cake on the wedding day. If delivered late, it becomes useless. Even without demand, there is already delay. And for the last exception, when demand would be useless. If it is already impossible for the debtor to perform, there is no need to demand. For example, the debtor promised to deliver a specific car, but already sold it to someone else. So remember, delay begins only upon demand by the creditor. However, demand is not required when the law or contract expressly provides it, when time is the controlling motive, or when demand would be useless. Now, let's classify delay into three types. First is mora solvendi. It pertains to the delay of the debtor, and it has two kinds. The first one is mora solvendi ex re. This is about an obligation to give. Example, I failed to deliver a specific car on due date after demand. The second kind of mora solvendi is mora solvendi ex persona. If mora solvendi ex re is about an obligation to give, this one is about obligation to do. Example, I failed to complete construction on time. If there is this delay, the effect is that debtor becomes liable for damages and even fortuitous events. Now for the second type of delay, mora excipiendi. It now talks about the delay of the creditor. This happens when the creditor refuses to accept performance without valid reason. For example, I am ready to deliver the car, but you refuse to accept it. This results several effects like the risk may shift to the creditor, and debtor may be released from responsibility. Now, for the last type of delay. We have compensatio mori. This occurs when both parties are in delay. And in effect, no one is considered in legal delay. Neither party can claim damages for delay, and neither can demand performance from the other. Now, another circumstance that affects obligation is the contravention of the tenor. In simple terms, this means violation of the terms of the obligation, even if there is performance. Example: I agreed to deliver a red car, but I delivered a black car. Here I performed, but incorrectly, and because of that, I am liable for damages. A classic case here is Arrieta versus Narek. In this case, the obligation was not performed according to agreed terms, resulting in liability. The Supreme Court emphasized that failure to comply with the exact manner agreed upon constitutes contravention of the tenor of the obligation. Now, for the last one. Let's discuss liabilities in case of obligation involving fortuitous events. Let's define this clearly. A fortuitous event is an event which could not be foreseen, or, though foreseen, is inevitable. Some examples of this are earthquake, flood, fire, and war. And it has elements. First is, cause is independent of debtor's will, meaning it is beyond the control of the debtors. Second, event is unforeseeable or unavoidable. Third, it make the performance impossible, and for the fourth element, the debtor has no participation or fault. As a general rule, there's no liability arising from fortuitous events. This is based on Article 1174 of the Civil Code, which states that no person shall be responsible for those events which could not be foreseen, or which, though foreseen, were inevitable. But again, this is not absolute. Here are the exceptions. The debtor is still liable if there is delay, fraud, or negligence. There is contravention of the tenor. There is assumption of risk. The law or contract expressly provides liability, or the debtor promised the same thing to multiple parties. So, class, what is the overall rule? Liability arises when there is fraud, negligence, delay, and contravention of the obligation. And remember that if these factors are present, liability may still exist, even with the occurrence of fortuitous events. Now, class, this is where everything we discussed becomes even more practical, especially from an accounting perspective. We've talked about obligations, risk of loss, and liability. The question now is, how does this translate into accounting? Let's connect it step by step. First is the breach of obligation and its consequence. From Article 1170, we learned that liability arises when there is fraud, negligence or delay, and contravention of the tenor of the obligation. Now, in accounting terms, once there is a breach, the obligation is no longer just a legal concept, it becomes a financial obligation. Meaning, the debtor may now owe damages, penalties, or compensation. And this creates liabilities in the books. So legally, the debtor or obliger who committed the breach is liable for damages. On the side of accounting, the debtor must recognize a liability or expense because the debtor may now be required to pay damages, penalties, or to give compensation. Now let's talk about penalties and provisions. In accounting, we follow IAS 37 when dealing with uncertain obligations. A provision is recognized when all of the following are present. First, there must be a present obligation. This can be legal or constructive, such as an obligation arising from a breached contract. Second, it must be probable that an outflow of resources will occur. In simple terms, this means that payment is likely. And third, the amount can be reliably estimated. Now let's connect this directly to our earlier examples. Suppose you failed to deliver the car on time, and now you must pay damages. From a legal perspective, under the Civil Code of the Philippines, you are liable for damages under Article 1170 due to delay. And from an accounting perspective, there is now a present obligation to pay damages, payment is probable, and amount can be estimated. So, when a legal obligation becomes probable and measurable, it is no longer just a legal issue. It becomes an accounting responsibility that must be recognized in the books as a provision. Here's a journal entry example for you. A company fails to deliver goods on time and expects to pay penalties. Our journal entry here would be debit expense for penalty or damages, then credit provision for liability. The expense account reflects loss, and the provision account reflects the obligation. Now, what if the situation is still uncertain? For example, there is a lawsuit. outcome is not yet decided, and payment is only possible, not probable. This is what we call a contingent liability. In accounting, if the obligation is not probable or cannot be measured reliably, we do not record it in the books. Instead, we only disclose it in the notes to financial statements. For example, a company is being sued for breach of contract, but the case is still pending. Here, there will be no journal entry and disclosure only, because it is only a possible obligation and not yet certain. So let's tie everything together. Earlier we discussed fraud, negligence, delay, fortuitous events, and breach of obligation. Now in accounting, these legal concepts determine when a liability arises. In summary, if there is no breach, there's no liability to be recognized in the books. But if there are breaches like fraud, delay, or negligence, the entity may recognize liability or provision. And in case of uncertain outcome, it may only require disclosure if the outflow is not yet probable and it cannot be reliably estimated. So remember this, class. Law tells you when you are liable. Accounting tells you how to record that liability. And the key bridge between the two is IAS 37, because not all obligations are recorded immediately. Some are recognized, which include setting provisions, or merely disclosed, like for contingent liabilities. Now you can clearly see that obligations are not just legal theories. They directly affect financial statements, expenses, and decision-making in real business situations. And that's why this topic is very important, not just for law, but especially for you as future CPAs. Thank you for listening, and I hope you learned something from this video lecture. See you in the next module.